The Fair Housing Act protects people from discrimination when they are renting, buying, or securing financing for any housing. The prohibitions specifically cover discrimination because of race, color, national origin, religion, sex, disability, and the presence of children. 1. What housing is covered? The Fair Housing Act covers most housing. In some circumstances, the Fair Housing Act exempts owner-occupied buildings with no more than 4 units, single-family housing sold or rented without the use of a broker, and housing operated by organizations and private clubs that limit occupancy to members. 2. What is prohibited? In the sale and rental of housing, no one may take any of the following actions based on race, color, national origin, religion, sex, familial status, or handicap. Refuse to rent or sell housing. Refuse to negotiate for housing. Make housing unavailable. Deny a dwelling. Set different terms, conditions, or privileges of sale or rental of a dwelling. Provide different housing services or facilities. Falsely deny that housing is available for inspection, sale, or rental. For profit, persuade owners to sell or rent, blockbusting. Deny anyone access or membership to a facility or service, such as multiple listing services, related to the sale or rental of housing. In mortgage lending, no one may take any of the following actions based on race, color, national origin, religion, sex, familial status, or handicap, disability. Refuse to make a mortgage loan. Refuse to provide information regarding loans. Impose different terms or conditions on a loan, such as different interest rates, points, or fees. Discriminate in appraising property. Refuse to purchase a loan. Set different terms or conditions for purchasing a loan. In addition, it is illegal for anyone to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right or assisting others who exercise that right. Advertise or make any statement that indicates a limitation or preference based on race, color, national origin, religion, sex, familial status, or handicap. This prohibition against discriminatory advertising applies to single-family and owner-occupied housing that is otherwise exempt from the Fair Housing Act. 3. Additional protection if you have a disability. If you or someone associated with you have a physical or mental disability, including hearing, mobility, and visual impairments, chronic alcoholism, chronic mental illness, AIDS, AIDS-related complex and mental retardation, that substantially limits one or more major life activities. Have a record of such a disability. Are regarded as having such a disability. Your landlord may not refuse to let you make reasonable modifications to your dwelling or common use areas at your expense if necessary for the disabled person to use the housing. Where reasonable, the landlord may permit changes only if you agree to restore the property to its original condition when you move. Refuse to make reasonable accommodations in rules, policies, practices, or services if necessary for the disabled person to use the housing. Example: a building with a no pets policy must allow a visually impaired tenant to keep a guide dog. Example: an apartment complex that offers tenants ample, unassigned parking must honor a request from a mobility-impaired tenant for a reserved space near her apartment if necessary to assure that she can have access to her apartment. However, housing need not be made available to a person who is a direct threat to the health or safety of others or who currently uses illegal drugs. 4. Requirements for new buildings. In buildings that are ready for the first occupancy after March 13, 1991, and have an elevator and 4 or more units, public and common areas must be accessible to persons with disabilities, and doors and hallways must be wide enough for wheelchairs. All units must have an accessible route into and through the unit, accessible light switches, electrical outlets, thermostats, and other environmental controls, reinforced bathroom walls to allow later installation of grab bars, and kitchens and bathrooms that can be used by people in wheelchairs. If a building with 4 or more units has no elevator and will be ready for first occupancy after March 13, 1991. These standards apply to ground floor units. These requirements for new buildings do not replace any more stringent standards in state or local law. 5. Housing opportunities for families. Unless a building or community qualifies as housing for older persons, it may not discriminate based on familial status. That is, if not housing for older persons, you may not discriminate against families in which one or more children under 18 live with. A parent. A person who has legal custody of the child or children. The designee of the parent or legal custodian, with the parent or custodian's written permission. Familial status protection also applies to pregnant women and anyone securing legal custody of a child under 18. Exemption. Housing for older persons is exempt from the prohibition against familial status discrimination if the HUD Secretary has determined that it is specifically designed for and occupied by elderly persons under a federal, state, or local government program. It is occupied solely by persons who are 62 or older. It houses at least one person who is 55 or older in at least 80% of the occupied units, and adheres to a policy that demonstrates an intent to house persons who are 55 or older. A transition period permits residents on or before September 13, 1988, to continue living in the housing, regardless of their age, without interfering with the exemption. If you think your rights have been violated, HUD is ready to help with any problem of housing discrimination. If you think your rights have been violated, the Housing Discrimination Complaint Form is available for you to download, complete, and return, or complete online and submit. Or you may write HUD a letter or telephone the HUD office nearest you. You have 1 year after an alleged violation to file a complaint with HUD, but you should file it as soon as possible. Step 1. What to tell. HUD. Your name and address. The name and address of the person your complaint is against, the respondent. The address or other identification to the housing involved. A short description to the alleged violation, the event that caused you to believe your rights were violated. The date of the alleged violation. Step 2. Where to write or call. Send the Housing Discrimination Complaint Form or a letter to the HUD office nearest you, or you may call that office directly. A toll-free TTY phone number for the hearing impaired, 1-800-927-9275. Interpreters, tapes and braille materials, assistance in reading and completing forms. What happens when you file a complaint? HUD will notify you when it receives your complaint. Normally, HUD also will. Notify the alleged violator of your complaint and permit that person to submit an answer. Investigate your complaint and determine whether there is reasonable cause to believe the Fair Housing Act has been violated. Notify you if it cannot complete an investigation within 100 days of receiving your complaint conciliation. HUD will try to reach an agreement with the person your complaint is against, the respondent. A conciliation agreement must protect both you and the public interest. If an agreement is signed, HUD will take no further action on your complaint. However, if HUD has reasonable cause to believe that a conciliation agreement is breached, HUD will recommend that the Attorney General file suit. Complaint referrals. If HUD has determined that your state or local agency has the same fair housing powers as HUD, HUD will refer your complaint to that agency for investigation and notify you of the referral. That agency must begin work on your complaint within 30 days, or HUD may take it back. What if you need help quickly? If you need immediate help to stop a serious problem that is being caused by a Fair Housing Act violation, HUD may be able to assist you as soon as you file a complaint. HUD may authorize the Attorney General to go to court to seek temporary or preliminary relief, pending the outcome of your complaint, if irreparable harm is likely to occur without HUD's intervention. There is substantial evidence that a violation of the Fair Housing Act occurred. Example: a builder agrees to sell a house, but, after learning the buyer is black, fails to keep the agreement. The buyer files a complaint with HUD. HUD may authorize the Attorney General to go to court to prevent a sale to any other buyer until HUD investigates the complaint. What happens after a complaint investigation? If, after investigating your complaint, HUD finds reasonable cause to believe that discrimination occurred, it will inform you. Your case will be heard in an administrative hearing within 120 days unless you or the respondent want the case to be heard in federal district court. Either way, there is no cost to you. The administrative hearing. If your case goes to an administrative hearing, HUD attorneys will litigate the case on your behalf. You may intervene in the case and be represented by your own attorney if you wish. An administrative law judge, ALA, will consider evidence from you and the respondent. If the ALA decides that discrimination occurred, the respondent can be ordered to compensate you for actual damages, including humiliation, pain, and suffering. To provide injunctive or other equitable relief, for example, to make the housing available to you. To pay the federal government a civil penalty to vindicate the public interest. The maximum penalties are $16,000 for a first violation and $70,000 for a third violation within 7 years. To pay reasonable attorney's fees and costs. Federal District Court. If you or the respondent choose to have your case decided in federal district court, the Attorney General will file a suit and litigate it on your behalf. Like the ALA, the district court can order relief and award actual damages, attorney's fees, and costs. In addition, the court can award punitive damages. In addition, you may file suit. You may file suit at your expense in federal district court or state court within 2 years of an alleged violation. If you cannot afford an attorney, the court may appoint one for you. You may bring suit even after filing a complaint if you have not signed a conciliation agreement and an administrative law judge has not started a hearing. A court may award actual and punitive damages and attorney's fees and costs. Other tools to combat housing discrimination. If there is non-compliance with the order of an administrative law judge, SHUD may seek temporary relief, enforcement of the order, or a restraining order in a United States Court of Appeals. The Attorney General may file a suit in a federal district court if there is reasonable cause to believe a pattern or practice of housing discrimination is occurring.